Negotiating terms with venture investors, the structure of venture capital investments, and the negotiation of key provisions. There are several steps in the process of negotiating financing terms with venture capital investors. One thing for entrepreneurs to consider in the initial presentation and discussion stage is that venture investors usually refuse to sign NDAs, confidentiality agreements. So the pitch to the investor must be made without disclosing any trade secrets or highly confidential information. The term sheet usually comes from the venture investor and outlines the amount of funding that would be provided and key terms of the investment. This slideshow deals with the key issues that are commonly negotiated in relation to the term sheet. Once the terms are agreed, the term sheet is executed, signed by the investor and the officers representing the company. The confidentiality and no-shop or standstill provisions of the term sheet are binding, but the investor's commitment to invest is not binding. That's contingent upon satisfactory due diligence. In the due diligence stage, lawyers investigate the company and its founders. The definitive contracts are drawn up by the attorneys, and hopefully they match the terms agreed in the term sheet. Finally comes the closing, when the contracts are signed and the funds are transferred. Negotiations are taking place between the investor and the company throughout this process. There are several parties to the negotiations. The venture partner champions the investment within the VC firm and leads the negotiation of the terms. The venture investor usually has an investment panel made up of some or all of the venture partners, and it's necessary for this panel to approve the investment. On the company side, the entrepreneur and management are involved in negotiating the terms. The company's board of directors approves the terms and usually needs further approval from the shareholders. Much of the negotiation takes place via lawyers representing the company and lawyers representing the venture investor. Venture investors have adopted preferred stock as their investment instrument of choice. Under this system, technology startups usually have two different forms of shares, common and preferred. If stockholder rights were a pizza, common stock would be a plain piece of dough with no cheese, sauce, or any toppings at all. And preferred stock would be stacked with elaborate ingredients, sauces, cheeses, and toppings selected by the investor. Founders and employees get plain old common stock, while investors enjoy elaborate preferred stock creations. Preferred and common stock structures allow for differential pricing. Under the preferred common two-tiered stock structure, the company is able to issue common stock to employees at prices significantly lower than the price at which preferred stock is sold to investors. There are some SEC guidelines in the United States that govern how far apart the price of common and preferred stock are allowed to be. In addition to providing the control mechanisms the venture investors seek, there are significant tax benefits to this two-tiered common preferred stock structure. As we will explore further in subsequent slides, there are special rights for holders of preferred stock that are not extended to the founding entrepreneurs or other holders of common stock. Preferred stock, also referred to as preference shares, are a hybrid combining features of equity with features of debt. They provide the venture investor with the best of both worlds: equity in the company like common stock, and liquidity preferences as they would get as a creditor providing the funds as a loan. Venture investors almost always structure their investments in the form of preferred stock. Like common stock, the properties of preferred are prescribed in state corporation codes and the corporate articles and bylaws. Preferred stock represents an equity interest in the corporation, but it's considered a hybrid of both common stock and debt. Preferred stock is in a junior position to debt when it comes to liquidation and bankruptcy. Although preferred stockholders cannot usually force the company into involuntary bankruptcy, venture investors can add these rights to the terms they demand in exchange for the funds they invest. However, preferred is senior to common. Dividends to preferred holders come before payments to common stockholders. Preference shares are essentially common stock with additional contractual rights provided in the stock purchase agreement. The preferred stock is issued under provisions of the company's Articles of Association and bylaws. The articles in most technology startups provide the board of directors with a blank check to create preferred stock as and when it's needed. The articles and contractual rights can be trumped by the law of the state of Delaware or the state in which the corporation was formed. Delaware has certain statutes controlling how preference shares can be issued and the rights of the corporation and preference shareholders. Venture investors are accustomed to these statutes and typically prefer Delaware corporations as they feel comfortable with the Delaware law as it's applied to preferred versus common stock. The preferred stock structure adopted by venture investors is somewhat unpalatable to Wall Street investors and other investors in the public stock markets, as it creates a complex capitalization structure and seriously affects the value of common stock. So immediately prior to IPO, the preferred stock converts to common, and the contractual rights of the preferred shareholders are lost. Conversion of preferred to common is normally set at a ratio of 1:1. One preferred share converts to one common share. However, as we'll see in another slide, anti-dilution provisions can adjust this conversion ratio. Common stock usually has advantages over preferred when it comes to declaring dividends. However, preferred stock is convertible to common. So, convertibility allows the preferred holders to achieve the best of both worlds. Upside potential as common stock and downside protection when treated as a creditor. Preferred acts as a second class of common stock with a liquidation preference and other contractual rights that we will cover in the upcoming slides. Anti-dilution rights are designed for investors to protect themselves from future rounds of funding at a lower price. They operate by manipulating the rate at which preferred stock converts to common. Although there are anti-dilution protections provided to investors, they're not usually provided to founders or other holders of common stock. In fact, the anti-dilution rights can significantly accelerate the dilution of the founders. There are two common formulas for calculating how the anti-dilution measures are implemented when a later B round is raised at a lower price than the earlier A round. The full ratchet formula is investor-friendly and can mean the A round investors have all their A round shares repriced to the lower B round price. The weighted average formula is considered more fair to the founders and holders of common stock. Again, the A price is adjusted, but not as low as the B price. This means the common stockholders are not diluted as heavily as they are under the ratchet arrangement. These anti-dilution rights can have a significant impact on the value of shares held by the founding entrepreneurs, and this issue is often heavily negotiated by each side. Another provision designed to prevent the venture investor being diluted when the company raises new funding refers to participation rights. Participation rights provide an investor in one round with a right to invest pro rata in future financings in order to retain the same percentage share of the company. The old investor has a right to participate in the new round on equal terms to the new investor. So an investor with participation rights, holding 30% of the shares after the A round, has a right to buy shares in the B round to maintain its 30% position. The participation rights differ from anti-dilution rights, as here the investor has to pay to play. The investor has to acquire the new shares at the new share price. With anti-dilution rights, the new shares are issued without the investor paying anything at all. The conversion rate at which preferred stock becomes common stock does not have to be adjusted. Participation rights usually merely involves selling new shares to existing shareholders. Liquidation preference is a significant provision that is often heavily negotiated in venture capital investments. At liquidation, usually involving the sale of the company, when the proceeds of the sale are shared among the shareholders of the acquired company, the investors stand in line ahead of the founders and the other holders of common stock. The investors take their money out first, then share what's remaining with the common shareholders. According to the liquidation preference, a founder holding 25% of the company in the form of common stock does not qualify for 25% of the proceeds of the sale of the company. There are essentially two forms of liquidation preference: participating and non-participating. With non-participating preferred, the investor chooses to either convert to common or recover the investment they injected in the company, plus some interest. With participating preferred, the investor recovers the investment, then gets to convert the preferred stock to common and participate with common shareholders in the sharing of the remaining proceeds. Investors, understandably, look to negotiate a participating preferred arrangement. Clearly, this can have a huge impact on the entrepreneur's payout if a substantial amount of equity is raised by the company. Each new round of funding pushes the founders further back in the queue when the proceeds of the company sale are shared out. In many cases, as a result of the liquidation preference, the entrepreneur may see little or nothing from the proceeds of the company sale. The negotiation between the entrepreneur and the investor usually revolves around the extent of the liquidation preference. An investor may argue that it should receive 2 times its initial investment before the participating with the common shareholders, or even more. But the entrepreneur may argue that a 1x return is more reasonable. As part of the financing process, the venture investors may request the restructuring of the founder's stock and the schedule on which it vests. The investors want to keep the founders incented to stay with the company and can require founders' stock to vest in upcoming years. Even previously vested shares can be affected. The equity incentive stock option pool is another issue for negotiation. Investors want a pool representing 15 to 20% of the company's shares to be set aside for new hires. The dilution to make this 15 to 20% carve-out possible is usually at the expense of founders' stock. So this is certainly a topic of negotiation between the founders and the venture investor in a round of financing. Most term sheets include a no-shop or standstill provision restricting the company from talking to other investors for a period of time once the term sheet is signed. This prevents the term sheet being shopped to other investors and allows the fund to invest in the due diligence process. This restriction on the company can, however, cut off alternative sources of investment if the lockup involves a long duration of time. What constitutes a reasonable length of time for a no-shop provision is a topic of negotiation. Preferred stockholders have special powers to elect board members. Series A round investors may have rights to elect a board member regardless of the votes held by the common stockholding founders. In a typical scenario, the Series A investor elects a venture partner to the board of directors. The Series B investors elect another venture partner to the board, and the common shareholders have a right to elect one board member, often the company founder or CEO. It's not uncommon for the venture investors to control the board of directors through controlling a majority of the board seats, from the point the first investment is made by venture capital investors up to the point that the company files for IPO. When it comes to the appointment of management, the CEO and officers are appointed by the board of directors, and the board of directors is elected by the shareholders, with investors having special rights to elect their own board members. The CEO effectively acts as an agent of the board of directors, and the board of directors has the power to hire and fire the CEO and other officers. Although he or she holds no votes on the board of directors, a powerful member of the team is often the outside counsel. After the venture investors have backed the company, it's somewhat customary for the company to hire a lawyer as outside counsel that's represented other companies in the portfolio of the venture investor. Preferred stockholding investors have rights to veto certain decisions. These rights to veto or approve significant decisions are often known as protective provisions, approval rights, or negative covenants. Examples of decisions carrying veto rights for the preferred stockholding investors include a sale of the company, all or substantially all the company's assets, or the issuing of new securities, amendments to the company's articles or bylaws, and other decisions affecting the interests of the shareholders. So as a result of these voting rights, it's the investors, not the founders, that decide whether the company is sold, new shares are issued, or finance is raised. Drag-along rights provide majority shareholders with the power to force minority shareholders to sell in a situation where the company is considering an acquisition offer. When the investor decides to sell his own shares, the founders and others can be forced to sell as well. Where co-sell rights are negotiated into the financing terms, company founders and common shareholders are restricted from selling their own shares pre-IPO without investors having the opportunity to sell alongside. Co-sell rights prevent the investor being left out if the founders sell their shares. Sometimes carve-outs are negotiated, allowing the founders or the founders' heirs to sell a small number of shares in certain situations, such as the death of the founder. Co-sell rights are usually accompanied by a right of first refusal. The founder must offer the company and/or the investors the opportunity to buy shares before selling to another buyer. Redemption rights enable the investor to demand the company repay the funds invested back to the investor plus interest. Usually redemption rights kick in after a period of time, such as 3, 4, or 5 years after the investment is made. The repayment terms can be negotiated as a lump sum or spread over a time via a payment schedule. The company usually needs time to repay. Redemption rights are more common for minority investors like individual angels and smaller investors, as they don't have sufficient preference shares to control exit decisions, like the decision to register for IPO or sell the company to an acquirer. The venture partners, supported by the firm's lawyers, are clearly protecting the interests of the VC fund. The company lawyer is representing the interests of the company. So who's protecting the interests of the entrepreneur in these negotiations? Well, a savvy entrepreneur may wish to hire a lawyer to represent his or her own interests when terms are negotiated with venture investors. Lawyers are specialists, and it's important to select an attorney with experience in the field of venture investments, but ideally someone relatively independent of the VC community, someone prepared to vigorously negotiate terms protecting the entrepreneur.